treated her, she treated him. They treated each other so well that they were their equal opposite, evil match for each other.
Every few weeks, I get to escape and have amazing adventures with my goddess lover, but I sense permanent freedom is coming.
They're also on top of this small body that was wrapped in completely black plastic.
I guess that'll be the question I'll die with, is asking why, and I don't think there's an answer.
The Doomsday Prophet murder trial rolls on, but has the prosecutor made himself a witness in the case? And shocking dashcam video shows a scamming victim turn into a defendant as he allegedly shoots an Uber driver out of fear. Plus, we're breaking down the facts surrounding Sade Robinson's gruesome murder with our own investigative experts. It's all coming up next for you right here on Opening Statements. Good Wednesday morning to you and welcome to Opening Statements. I'm your host, Julie Grant. This show is just like the actual opening statements at trial. At least that was the premise of it for the start. We want to get you all primed, ready to go, ready to hear the case evidence in the big cases we're covering both at trial and the world of true crime. So right now, why don't you go ahead and grab a cup of coffee? It's morning time and it's time for my opening statement. Murdered on a first date. That's what police in Milwaukee say happened to Sade Robinson. The beautiful, vibrant 19-year-old college student was a beloved daughter, sister, and friend. On April 1st, her life was cut tragically short in the most unthinkable way. Police say Sade Robinson was murdered, her body dismembered, and her car set on fire. All this after a first date, a dinner together at a seafood restaurant. Beautiful Sade Robinson never made it back home. Police say that they have their suspect behind bars, the man who went on that date with Sade. His name is Maxwell Anderson. And if what police say he did is true, this guy is a monster from down below. And if he killed her and dismembered her body, may he pay dearly for the crimes with the harshest penalties the law allows. You know, this morning, my friends, I'm thinking about how this case is still being investigated, and much of Sade Robinson's remains are sadly still missing this morning. I can't even begin to imagine the heartbreak and the agony that her family is going through right now. This is just the beginning of the criminal case, but it's also just the beginning of a lifetime of pain for her family. May they find some comfort in knowing that people all around the world are sending them love and light, honoring and remembering their beloved Sade. May she get justice, and may she rest in peace. That's my opening statement on this Wednesday morning. Let me know if you like it. Right now, it's time for your daily docket.
Tonight I figured out who I feel like. I'm a grown-up version of Harry Potter who has to live with the Dudleys in his little space under the stairs. Every few weeks, I get to escape and have amazing adventures with my goddess lover. But then I have to return to my place under the stairs, feeling trapped. But I sense permanent freedom is coming.
All right, here's a look at the cases we're following for you today on Court TV. In Idaho, testimony resumes at 10:30 a.m. in the Doomsday Prophet murder trial. In Massachusetts, jury selection continues at 9 a.m. in the killer or cover-up case against defendant Karen Reed. And in New York, suspected serial killer Rex Heuermann is due in court at 9 a.m. He's got a status hearing. For more on the trial of Chad Daybell, let's take you now to Boise, Idaho, where we find Court TV legal correspondent Kelly Craft standing by with the latest.
Good morning, Julie. Google searches about people dying and their bodies being possessed after death, and also searches for wedding dresses while in Hawaii. Just some of the evidence presented in this triple murder trial for Chad Daybell. Chad Daybell, dressed in all brown, wearing an ankle monitor, sat with his hands clasped, listening to detectives reveal messages sent to him by Lori's fourth husband, Charles Vallow.
The email reads, Chad, I'm Lori's husband, but I gathered you already knew this. She sent an email yesterday, supposedly written by me, to KK Walker, inviting you to Arizona next week and to ghostwrite a book I'm supposedly working on. It's preposterous. I happened to run across it as she left her computer at our Houston home. I am not paying anybody for anything, and I am not writing a book. Either you or Lori need to tell me what's going on, or this will be exposed for all to see. Regards, Charles Vallow. And does your wife know you have several of Lori's dance videos?
And in this case, did you learn who made that 911 call?
I did.
And who was that?
Alex Cox. Alex had contacted 911 and reported that he had shot his brother-in-law, Charles Vallow, in self-defense.
Also in court, a recording was played of Chad Daybell giving a blessing to Alex Cox, Lori's brother, in which Daybell tells Cox that he is here on earth to protect his sister, Lori. That's the latest from here in Boise, Idaho. Julie, back to you.
All right, our thanks to Kelly Craft for that early update. Now, before the end of the court day on Tuesday, a very interesting matter came before the judge as the state raised concerns that prosecutor Rob Wood could be called as a witness.
The arguments being made in the state of the cross-examination raised the state's concern that there could be another attempt by the defense to make Prosecutor Wood a witness, and specifically in relation to Miss Gibb. The state disclosed in this motion the content of the communications that we feel the defense may be relying on or may use. We are asking the court to consider either excluding the messages and or excluding Prosecutor Wood as a witness, or any attempt to call him as a witness, and or if necessary, if the court has additional concerns, that a taint hearing be conducted outside of the purview of the jury in order to determine whether or not we would get to that point of the defendant meeting that compelling need, which is a high burden.
So this issue is coming up because Prosecutor Wood was communicating with a key trial witness, Melanie Gibb, leading up to the trial without any other witnesses or people present, like police involved in the case, someone else perhaps from his office, from another division. Now, the defense team wants to use the over 300 messages between the prosecutor and Melanie Gibb on the cross-examination. And while defense attorney John Pryor, who represents Chad Daybell, says he has no intention of trying to call the prosecutor to the stand, those messages could put the state in a very awkward position. What a mess this is. For those of you who followed this case from its inception, I remember talking about this years ago, saying that one of the main things you always have to remember when you're a prosecutor is you never want to make yourself a witness in your own case. If you talk to a case witness all alone, and let's say you put that case witness on the stand later and they go south with their testimony, they don't say what they told you before in that conversation, guess who's got to testify? You. And what an embarrassment that is, because you're not supposed to become a witness in your own case when you're a prosecutor. This is a mess. I want to bring in two great guests to talk more about this messiness going on in Idaho. There they are. We've got with us criminal defense attorney and civil rights attorney Kesia Early, and criminal defense attorney and former prosecutor Franz Borghardt. All right, Franz, I want to start with you because you are our prosecutor here, formerly. Your thoughts on this prosecutor handling these death penalty cases, doing that with a witness?
It's a big mistake, right? And it could happen to any prosecutor. But the fact of the matter is, you're spot on. If you are prosecuting and you are communicating with a witness directly, you are exposing yourself to being a possible material witness. And the viewers may be like, well, a witness of what? You may be the only thing that allows for impeachment if that witness lies, if those communications are even deemed admissible. All this is good old-fashioned chaos, which aids the defense because it's a distraction from what? Whether or not the state proves beyond a reasonable doubt that this individual committed the crimes he's accused of and whether or not he should be sentenced to death. It's chaos, Julie, and it's a good defense tactic because the prosecution has put themselves in this position.
Right, Franz, they're capitalizing on it. Casey, my question for you deals with John Pryor, the defense attorney, saying he's being handcuffed here. I've got a clip, and I'm going to talk to you on the other side about it. Let's watch.
This is my concern, is what the state is suggesting is that in some way they can dictate where I can go on cross-examination. They would like this court to enter an order saying, Mr. Pryor can only talk to certain witnesses about certain topics in a certain way, and they're trying to handcuff me from going into areas that they will find maybe a little sensitive to their case. They don't have the authority to stop me from questioning a witness about communications with either a police officer or a prosecutor and try to show credibility, bias, or motive.
Okay, so John Pryor's saying he shouldn't get to cross on just some of it. He should be able to cross on all of it. Casey, as a criminal defense attorney, do you think he's right?
Well, it depends. I'll give you the classic lawyer response, but I do agree with a portion of his argument that he should not be held to just a portion during his cross-examination. That is the purpose of cross-examination, is to attack the credibility of the witnesses and show reasonable doubt from the state's case in chief. So I do agree, but I also believe that the judge should make a ruling early on and not wait until this trial goes on to see whether or not that communication, if the lawyer has, in this case right now, made himself a witness. And we know that the rules of evidence state that lawyers can talk to witnesses, although I've never been on the other side, but you want to be very careful that you don't put yourself in a position where you're not a witness and it takes away from your case or you handle in that case. So like my colleague said, this is really messy and the judge needs to make a ruling quickly.
Definitely, Casey. Speaking of that, I've got a clip where the judge gives his ruling about Melanie Gibb and Rod Wood and the messages and the calling him as a witness. Let's watch.
The court's going to deny the motion as it relates to a motion to eliminate, to just exclude Exhibit 113. Just have to see how the trial develops with the testimony of that witness. However, I will state that I'll be watching very carefully as to whether or not there really is any relevance to the testimony of Ms. Gibb.
Okay, so he's not just going to put them all in marked as an exhibit. He's going to let them in on a case-by-case basis, deciding statement by statement. Franz, back to you, please. Is that a good ruling by the court, in your opinion?
It's a good ruling in so much as we don't know, one, if these statements are relevant yet. They may become relevant at trial. We just don't know that yet. And it would be premature to exclude them without knowing if they're relevant or not. Secondly, we don't know, even if they may not be relevant, we don't know if the state is going to open the door to their relevance and their case in chief. So I think this is the right ruling. The judge's job is not to undo the mess of the prosecution, and they may have to live with it. And then furthermore, if he excludes those statements and he stifles the defense's right to confrontation, which is a constitutional right, then it creates a huge appellate issue that didn't exist before the prosecution made the mistake of doing what they did.
Appreciate it. Franz Borghardt, Casey Early, stand by for more questions, please. When we come back, here's what's next on Opening Statements.
I know what you're after. You're after this.
This is horrifying. Dash camera video from an Uber driver's car shows a scamming victim shooting and killing her. Was he a victim or was he a reckless aggressor? We'll talk about it next. And our investigators are weighing in on the tragic case of the murder of Sade Robinson. We've got the grisly details to share with you, and we're bringing in our own expert investigators.
We are underway in the trial of doomsday prophet Chad Daybell.
Prosecutors say they will seek the death penalty against him.
Investigators have recovered human remains at Chad Daybell's residence.
There's no way, Morgan. I could never come up with this.
His wife, Lori Vallow Daybell, has already been convicted.
Now, will her husband end up with the same fate?
It's just so hard to know where the truth ends.
It's the doomsday prophet, Chad Daybell, on trial.
Now for what's trending in true crime, an Uber driver in Ohio, police say was shot dead by an elderly man after the two were scammed into meeting.
Stop. Stop. Or I'll call 911.
This is just dreadful. The confrontation, as you can see, was caught on Uber driver Lolitha Hall's dash camera. There she is, and there's 81-year-old William Brock. Now, he says that someone had been calling him, demanding money, and making threats before Hall arrived. The sheriff's office says that someone instructed her to go pick up a package at his home. Police say after Brock shot Hall, he called police saying that someone was trying to rob him.
I need the sheriff and the ambulance real quick out here. There's been a shooting. Well, I shot her in the leg the first time, then I shot her in the shoulder. Guy on the phone has been trying to get money out of me. And he was telling me he was going to kill me and the family and everybody else around.
So William Brock is out on bond this morning. The sheriff's office is investigating the original scam calls, but the alleged scammer has not been arrested. So it's important to understand here, they were both scammed. But this is dreadful. You know, we have Lolitha Hall shot and killed. So this woman was shot and killed after she was set up to go get the package. And then the homeowner is now going to police as a victim, but also, remember, he killed someone here. So is he a reckless aggressor or is he a victim? Let's bring in our guest and talk more about this. Criminal defense attorney and civil rights attorney Kesia Early is still with us. So is criminal defense attorney and former prosecutor Franz Borghardt. And we want to welcome into the discussion entertainment reporter Kinsey Schofield. Wonderful to have you all here. Kesia, I'd like to start with you, if I may, please. Would you kick us off? Is this guy a reckless aggressor or is he a victim?
Well, Julie, I tell you what, he's not. He's not a victim. I mean, although he had these annoying calls, these scam calls, you have to show harm if you're the victim. So was he defrauded from any money? Was he physically attacked? So no, he technically at that point was not a victim. The true victim, obviously, in this case was Ms. Hall, who, unbeknownst to her, was taking this Uber trip to pick up a package. And thank goodness she had the dash cam to show that not only was she trying to get away, she was calling for help. And he went ahead and not shot her once, but twice. And then he contacted law enforcement. So it shows that he could have contacted law enforcement even after the first shot. His actions were excessive. And ultimately, unfortunately, she passed from his actions.
Mm-hmm. Right, Kesia, this is just dreadful. I like the point you made about he could have called 911 immediately when someone shows up to get a package and it was unexpected, he's being scammed. Why didn't the call happen then? Franz, to you next, please. I see you nodding in agreement. Your thoughts, please.
I think this is going to be a homicide. I don't see any true self-defense claim, although his defense attorneys are going to argue, look, you know, he was under duress, he had just gotten scammed. It doesn't seem to be a fact in dispute that both of these individuals were scammed. But I agree. Why not call the police? Like, why not call the police after you have her at gunpoint? Why do you have to shoot her? So he has some issues, right? Self-defense is not going to work. He has some issues with regard to, he has a strong mitigation argument. I think it's going to become a question of which type of murder is he ultimately charged with. And then I think the prankster, the person that orchestrated this, is going to be charged with a higher form of murder.
I sure hope so, Franz. That's a great point. Thank you for that. Kinsey Schofield, last but certainly not least, to you next, please. This case has a lot of people talking. Share with us the public sentiment that you're seeing on this one, please.
I mean, obviously, when it comes to this story, people are very emotional about it because who doesn't have the Uber app on their phone? Uber has detailed descriptions of how they work with law enforcement. Typically, whenever there are incidents, their website says that they share names, contact numbers, and email addresses, and that the police can request any additional information if they need to via Uber's public safety response portal. And that information could consist of the IP addresses that the accuser used while accessing the Uber app to arrange this meeting, or the email address associated with that account. That IP address could direct them to a geolocation, city, or zip code. And so, you know, there is a very good chance that the perpetrators could be located based on their digital footprint. And that's really the conversation happening online right now.
Wow, Kinsey, thank you for that. I sure hope that they are, and I hope that it can be done swiftly, and there can be a prosecution with the heaviest of consequences, as Franz said. We'll leave it there for now. Our hearts, of course, going out to Lolitha Hall's family. Let's turn to some other big trending news right now. The mayor of Atlantic City and his wife have been charged with abusing their teenage daughter. Police say Mayor Marty Small assaulted his daughter multiple times, including hitting her in the head with a broom, knocking her unconscious. He also allegedly threatened his daughter, threatened to throw her down the stairs and, quote, smack the weave out of her head. His wife, Atlantic City superintendent of schools, is accused of punching the girl in the mouth and in the chest. Now, the Smalls, through their attorney, are calling this a private family matter. So here's what we're wondering this morning. When does a family matter become the public's concern? Let's talk about it with our power panel. I want to bring them back in. Entertainment reporter Kinsey Schofield, I'd like to begin with you on this one, please. You're our journalist on the panel. Your thoughts on when something private involving a mayor in a school district superintendent become something that the public has an interest in?
Well, yeah, I mean, I think they are both public figures. With his wife working with young adults, when you are in positions of leadership, there is a microscope on you and there are higher expectations. When you pursue a career in public service, you know that there are sacrifices, you know, like the privacy of your family on display for the media to dissect. I think, unfortunately, this, in the court of public opinion, potentially this is the nail in the coffin for Mayor Marty Small's political career, because people are affected by these reports, whether they're true or not. They're going to stay with individuals.
That's a good point, Kinsey. Thank you for that. April is also, as we know, Child Abuse Awareness Month. Casey, I want to go to you next, please. You're a big advocate for child abuse prevention. You've done a lot of cases in the juvenile court system. When you hear these facts, and this is a teenage girl, you know, growing up in the home and allegedly being subjected to this kind of physical and verbal abuse. What goes through your mind, please?
Protect and save our children. I'm a mother of 3 teenagers, and there's a fine line between parental discipline and child abuse. And clearly, these allegations are serious and amount to child abuse, especially when you're utilizing anything as a form of a weapon and you're knocking your children, or child in this case, unconscious. And this is definitely public concern because it's public record, because these are criminal charges. And I do agree with Kinsey that, you know, this can definitely end his career if these charges are, if he's found guilty of these charges or is resolved with a plea. But we have to protect our children. There's other ways that you can discipline, whether you're taking away items, but physical discipline is unsafe in this particular instance where she was knocked unconscious. So I'm very concerned about this child in this case.
Exactly. Casey, thank you for that. Franz Borghardt, last but not least, take us home on this case. Your thoughts, please.
Well, using the phrase, this is a personal matter, to me is horrible optics. They need to fire their marketing person, hire Kinsey. I think bigger picture, I think bigger picture, the right to parent ends. Your constitutional right to choose how to parent ends when a child gets abused, right? And if in fact the state proves that this teenager was in fact abused, and they have to prove this, right? If they prove it, it's a huge, huge problem that both of these parents were doing this, right? If you don't have a good soundbite, stay quiet, exercise your right to remain silent. Yes, it's going to destroy your political future, but they need to be worried about jail time. And that is a legitimate issue in this case.
Right, Franz. And I really do like what you said about optics. Two public figures should know better than anybody. Optics matter, words matter. And we didn't see, the outright denial or anything like that. It was just, this is a private family matter. And as you said, people want to know that their daughter is safe and that she's living in a safe home and unharmed. We'll leave it there for now. Wonderful having you all on the Power Panel this morning. Casey Early, Kinsey Schofield, and Franz Borghardt. Thank you all kindly. When we come back, here's what's next on Opening Statements.
It brings me more to heartbreak. I still can't believe this is happening. It's not easy losing someone you love, blood or not,
We've got our own investigative experts here on the program to go over the grisly details in the death of 19-year-old college student Sade Robinson. Plus, the judge's big ruling in the case against homicide defendant Karen Reed. Will we see justice for the deceased police officer John O'Keefe? It started out as a first date, but then it turned into a gruesome nightmare. This morning, we're shining a spotlight on the murder of 19-year-old Sade Robinson and her alleged killer. Robinson's coworkers say that she was excited about dinner with 33-year-old Maxwell Anderson. A criminal complaint states that after dinner and drinks on April the 1st, they arrived at Anderson's home around 9 p.m. Sade Robinson was never seen alive again. And the following day, body parts began showing up in downtown Milwaukee. First, it was a leg, which has been identified as belonging to Robinson. And search parties are still looking for more of her remains.
She was bright, always, making feel people welcomed. She looked out for my baby. The least I could do was look out for her mama's baby.
We need to do whatever we can to bring her home. Until we find out what we need to find out, we just come out and you just keep pushing forward. And we let the experts come and decide, determine what they know. And we're just the eyes and the ears on the ground.
Now, Anderson is charged with first-degree intentional homicide, mutilating a corpse, and arson of property other than a building for allegedly torching Robinson's car. We have our own investigative experts on the show this morning, both with extremely impressive backgrounds, here to dissect these grisly facts for us. Let's bring them in now. The chief of police at Talladega College and retired homicide detective Chris Anderson, and professor and retired NYPD detective Mike Alcazar. Good morning to you both. Oh my, this is one of those cases it's hard to even think about, yet it happened. Sade Robinson's family is grieving in so much pain and agony. It's hard to imagine as officers and members of search teams are coming together to look for the rest of her remains. What I want to start with, please, is the fact that we've got this guy very quickly behind bars, this Maxwell Anderson, this alleged monster. But what else are detectives doing right now? I would love for you both to pull back the curtain for us and kind of take us to work with you. If you were working this case, what are some of the things that you're doing right now to make sure you have this solid case against this guy that you believe murdered that beautiful young woman? Chief Anderson, I'd like to start with you first, if I may, please.
Well, first off, I want to offer my deepest condolences to the family and friends of Sade Robinson. This is a terrible, terrible case that you just hate to see, not only as an investigator, but as a father. These are the cases that you just despise. Pulling back those curtains from an investigative standpoint, the number one thing that you want to do is make sure that the victims' families and her friends find justice. So you work this case starting from top to bottom. I mean, evidentiary, you try to find your best investigators to help you out in your evidence gathering. Number two, you make sure that you've interviewed every witness that you can possible in this case. And number three, you get a good statement from the defendant, if at all possible, in order to make sure that this case is well prosecuted and the district attorney has a sound foundation of what they on how they will move when the case is prosecuted.
Chief, thank you kindly for that. You mentioned the defendant. I want to focus on him next, please. Mike Alcazar, I want to go to you on this. Tapping into your detective experience, apparently a woman told Wisconsin TV station WISN that Maxwell Anderson has a sex dungeon in his basement. And we know police found blood in his basement. What does this information mean to you if you're investigating the case?
So that's huge information. We're going to process his house. We're going to collect every evidence we can get from there, any kind of DNA, any potential DNA from potential other victims, from Sade, right? So that's important. We got to see if there's any DNA from Sade at the residence, which I think is going to strongly lead to that. What kind of tools or weapons or whatever information he has in his house that help facilitate this homicide. Also on the recovered body parts to see if this perp's DNA, his hair, his fibers, again, like the chief said, is to make for a stronger prosecution. Everything's for courtroom presentation. So it's important that they process the scene meticulously and to make a strong case for the jury.
Exactly. Detective, thank you kindly for that. I want to play a clip from Sade Robinson's mother. Let's watch.
This son of a is gonna pay. This is justice for Sade. Who the would do something like this to my beautiful baby? She hurt nobody.
If this Maxwell Anderson is the maniac that police say he is, and if what he is alleged to have done was carried out by him, he needs to pay dearly. And this morning, hearing the information about the sex dungeon, I'm wondering, Chief Anderson, do you think this guy could have done these things before? If he murdered Sade Robinson, if this went down like detectives believe it did with the first date and the luring to his home and the murder and the torching of the car, the cover-up, might he be someone you would look at for other homicides?
Absolutely, and that's an excellent question, and I think that is something that goes negated or we don't usually get this question, but as investigators, we always look to find out if there are other victims, because homicide is not a crime that just happens. In some cases, it does happen at the spur of the moment, but when you have a meticulous type murder, it takes planning, it takes practice, unfortunately. So absolutely, we would look at him in other cases, and especially if we have witnesses now that are coming forward who knows that this man has a sex dungeon in his home, you absolutely have to look for other victims, because in most cases, it just doesn't happen once. Sometimes it happens and the victim gets away. Sometimes it happens, and certain things that happen that took place during your date or during your contact with this suspect, you don't realize how important it is when it comes to a case like this. So yes, absolutely, you're going to look at him in other cases.
Chief Anderson, thank you for that. So a little bit that we know about Maxwell Anderson has come from some court records that we've looked at. Apparently, he has worked as a bartender. He is a Navy veteran. We know he was arrested 3 separate times for disorderly conduct between 2014 and 2019, which is a minor charge, we all know. And then he was recently arrested for operating a vehicle while impaired. So nothing on his record that indicates any kind of assaultive behavior or anything that would rise to the level of making him a repeat offender. No red flags there. But Detective Mike Alcazar, let me go to you on something I think a lot of people are thinking about. I know I am as I read read the facts of this case. Here we have this young woman with such a promising life ahead of her. She's going to school. She wanted to study criminal justice, of all things. She's 19, she's beautiful, she's vivacious, everybody loves her. And she goes on a first date. You know, she's wanting to meet someone, wanting to find love, goes on a first date with this guy and doesn't come home. And you look at it, and she did nothing wrong here. What safety tips come to mind that you can share with our viewing audience, please, Detective?
Yeah, I have a daughter that's 27, and I'm concerned for her safety all the time. You can't trust people these days. You should never go to an unknown person's house or residence where you're not in public. You just gotta be careful what you're consuming. We don't know if he did anything to her drink and brought her to the house. You just gotta stay in public, and just don't trust anybody, and definitely don't go into somebody's house. That's number one.
Isn't that the truth? Thank you for that, Detective. We do have a portion of their text message exchange on April the 1st. This is coming from the criminal complaint. Take a look at your screen. Here it is. Sade saying, where are we meeting? I can do 5. Maxwell saying back, downtown somewhere. She says, okay. He suggests Brat House on 3rd. She says, perfect. He says, okay, I'm going to shower quick. I'll probably get there more on 5:15. Are you hungry? I need to stop at Twisted Fisherman to pick up my W-2 from last year. We could eat there first. She says, okay, and yes. Are we eating at the Brat House or the other place? He said, let's eat at Twisted. I'm feeling seafood. She says, yes, I love seafood. He says, sounds good. I'm about to leave. I'll be there soon. Chief Anderson, you know, you hear this, and there's nothing that jumps out, is there, that could indicate danger, huh?
No, you're right. There's nothing there through those text messages that indicate dangers. But, you know, one of the tips that Mike touched on Professor Alcazar touched on several of those tips during his statement. But there are other tips that you need to be aware of, especially on the first date when you're just getting to know a person. And in no way, shape, or form are we saying that Sade is, you know, responsible or did anything wrong. She is an innocent victim. I want to make that clear. But there are certain things that, you know, we need to make sure that we understand as when you're going on a date. There are certain things that usually happen, you know, certain mannerisms, certain attitudes that you need to pay attention to. And also letting someone else know what's happening on the date, continuing to check in with others.
Oh, I like that. That's another great tip we can take along with us. Thank you both so much for this important discussion. Chief Chris Anderson, Detective and Professor Mike Alcazar, thank you both kindly for your time and expertise. We'll see you soon. When we come back, we're going to break down Tuesday's big ruling over the third-party culprit defense in the case against defendant Karen Reed. So will this decision tip the scales of justice in the favor of the Commonwealth?
Join Court TV's Vinnie Politan.
In every story, in every trial, every case, there's at least 2 sides to it.
To dive into the latest.
Oh my God.
And breaking true crime stories.
This was a very targeted, very personal attack.
Inside.
My whole life depends on it.
And outside of the courtroom.
She's a psychopath.
Now, let's look at the other side of all of that.
Vinnie Politan Investigates. Saturday morning, 10/9 Central. Only on Court TV.
Now, for what's tipping the scales of justice, jury selection enters day number 2 this morning in Boston in the killer or cover-up murder trial for defendant Karen Reed. This case is over the murder of police officer John O'Keefe. Now, a key focus ahead of trial, initiated by the defense team, is they're going so far as to say that other people did this crime. It's called a third-party culprit defense, something legally you can raise, but it's not without legal limits. You have to put forth certain things in order to be allowed by the court to raise it at trial. And so Friday, that was largely what the hearing was all about that we watched. Remember when the judge said to the defense attorney, well, who is the third-party culprit you're blaming? And he said, well, we don't have to disclose that, Judge. So we saw Tuesday, the judge made her ruling on how the defense will be allowed to make their case. Take a look.
Based on the offer of proof on Friday, I am well within my rights, pursuant to the case law, to exclude the third-party culprit defense. I'm not going to do that now. I'm going to give you a chance to develop it through relevant, competent, admissible evidence, but you cannot open on it.
Oh, so here's what the judge is doing. She's saying you've got to have evidence of this. Opening statements are not evidence. It's just lawyers spewing all sorts of things that aren't case evidence. The case evidence comes in through the witnesses, the testimony, the exhibits, all of that. So let's talk about how this might tip the scales of justice here. I have a great guest standing by. She is a professor of law. She's the author of the book, Oh No, He Didn't. She's also a former prosecuting attorney. And guess what? She is licensed in Massachusetts. Our friend Wendy Murphy on the program this morning. Good morning, Wendy. I want you to go into full-blown professor mode with us and take us to school. Third-party culprit defense in Massachusetts. How often do you see a defendant going so far as to point the finger at somebody else with specificity?
Oh, it's a really good way to frame the question, because I'm not sure we're even going to see that in this case. There's a difference, Julie, between saying someone else could have done this and this person did it. Those are very different things, and the law treats those things very differently. Obviously, a defendant who can say this particular person is actually the culprit and produce evidence showing that that person had the motive, means, and opportunity, that's a pretty good defense case. We don't have that here. I mean, even the defense concedes they don't have that. What they did do on Friday, and I think this is why the judge ruled the way she did, is, and I think you remember Mr. Yannetti stood up and said, because she said, tell me what you have. And he listed all these different things, and, you know, most of it was fairly inconsequential, not directly related to the case per se. But he threw up a couple of things, and she said, fine, you know, I'll issue my ruling next week. And what we heard the judge rule yesterday was basically, the defense didn't get her very far with its proffer, with its suggestion that we're going to have this little bit of evidence and that little bit of evidence, and altogether it's going to give us the ability to say, we don't know exactly who did it, but it was somebody else. That's really what the defense is claiming at this point. We don't know who did it, but it was somebody else. Now, they did make 3 names specific, you know, in people we know from the case. They said these 3 names are people we think are going to have enough evidence come out about their behavior at the time of the crime that we're going to sort of point in those directions. But what the judge said, which is so interesting, I heard some of the newscasts say, wasn't this good for the defense? What the judge said was, no, you didn't persuade me. I'll let you ask some questions, but I don't see any there, at least not yet. That's not good news for Karen Reed.
No, not at all. Not at all. Wendy, you're right. This was a big blow to the defense team, and it was a very fair ruling because she's stopping them from just being able to stand up there and throw out a wild theory, point the finger at people without the evidence to back it up. She's saying, put the evidence in, and it comes right in. And then in closing arguments, you can argue it all day long, but you're not going to do it right off the bat in opening statements. You got to show your evidence, since they didn't show it, as you said, Wendy, on Friday when the judge gave them the opportunity for that proffer.
And in fact, Julie,
sure,
there's a chance that once the evidence is out, the judge is going to say, and I'm not even going to let you argue it in closing because it didn't come out. Remember, she didn't just say you have to produce some evidence. It has to be relevant, competent, and admissible. If she decides once the evidence comes out that it's not all of those things, she can even ban the defense from making the argument at closing. At this point, that ban is only on the opening, but she could absolutely rule against them if it doesn't materialize the way the defense is suggesting it will.
I appreciate that point, Wendy. You're right. If it doesn't come in case evidence, it can't be argued at closing. The rules prohibit that. So that's another good point. If they can't come with the concrete evidence of specificity, we're not going to see it at all, and they won't get to argue it. So what they've been arguing on the courthouse stairs, on social media, through, you know, other people perhaps, may not be heard by the most important people, in this case, the members of that jury. We've got to leave it there for now, but Wendy Murphy, thank you for lending us your insight and professorial expertise. We'll see you soon on the show. Thanks so much. And that's all, my friends, for this episode of Opening Statements. You can watch it again if you want. You can share it if you want. Every day we put our shows up on courttv.com for you. Click on the shows tab to get them. When we come back, I'm coming along with you as we head to Tuesday's big hearing in the case against accused child killer Leilani Simon. Don't go away.